Ever wonder how a system from medieval England still shapes the laws we live by today?
It's like stepping back in time.
Right. Get ready for your own crash course in common law. We're going all the way back to its origins.
Uncovering the foundation of legal principles that, let's be honest, we probably don't think about every day, but really impact us all the time.
Exactly. We're talking kings, courts, a dash of rebellion. I mean, who doesn't love a good rebellion story, right?
Absolutely. And by the end of this deep dive, you'll be dropping legal history knowledge at your next cocktail party.
You'll be the life of the party. But okay, before we get too far ahead of ourselves, we need to rewind the clock. Way back. All the way back to 1066, the Norman Conquest of England.
1066. A pivotal moment, to say the least, and one that really sets the stage for this whole common law story to unfold.
So paint a picture for us. England before William the Conqueror waltzes in. What's the legal scene look like?
Okay, so picture this. It's fragmented, like really fragmented.
Oh, no.
Oh, yeah. Think more like a shattered mirror than a unified system. Different rules applying depending on where you were, which, as you can imagine, did not make for a very harmonious legal landscape.
So no consistency whatsoever.
Not so much.
I can only imagine the headaches that must have caused. It sounds like a lawyer's dream. Or maybe their worst nightmare. I can't decide which.
Right. And then, boom, enters William the Conqueror. Talk about a ruler with a vision. He was all about order and a unified England, which of course meant bringing the legal system under his control as well, centralizing power in a way that hadn't really been seen before.
So even back then, it's about politics as much as it is about justice.
Interesting.
It makes you wonder how much of that power struggle we still see reflected in our legal system today.
It's a question worth pondering, for sure. But yeah, with William at the helm, we see the rise of this powerful body, the King's Council, and they were really calling the shots. They held all the cards, basically.
Yeah.
Legislative, executive, you name it, they had a hand in it. Wait. So this King's Council, are we talking like a medieval super branch of government here?
Well, it wasn't quite as clear-cut as how we see the branches of government today.
Okay, that's fair.
But the King's Council, they weren't just deciding cases. They were crafting laws, advising the king, even acting as this kind of administrative body. It took a while for distinct courts to really emerge from this.
So how do we go from this all-powerful King's Council to the establishment of common law? What sparks that evolution?
Okay, so fast forward with me about 150 years. We hit the year 1250, and let me tell you, this is a big year for common law.
A big year. Okay, I'm intrigued.
Because before this, imagine justice being totally unpredictable, like a game of chance, varying wildly from one region to the next. But around this time, a revolutionary concept starts to take hold. Ready for it?
Hit me with it.
Precedent.
The idea that past decisions should guide future rulings. The very bedrock of common law as we know it.
Exactly, and it really was revolutionary for its time. Because what judges started doing was looking back at how similar cases had been resolved in the past. It wasn't about rigidly sticking to some ancient rule book. It was about using past experience to inform present judgments. And look, was it perfect? No. But it was a step toward some semblance of, consistency and fairness.
It's like building a legal structure, brick by brick, each case adding to the foundation. But speaking of building, how are they keeping track of all these cases? Was there some massive medieval database?
Okay, so you bring up a really important point. Because a system is only as good as its implementation, right?
Very true.
And that's where we encounter one of the more, shall we say, unique aspects of early common law, the writ system.
Okay, unique usually means things are about to get interesting. Tell me more of these writs.
Picture this. You want to seek justice in court, but you can't just, file a complaint. Instead, you have to find a pre-approved format, a writ, that matches your specific problem.
So it's like finding the right form at the DMV, except with potentially life-altering consequences.
High stakes, for sure. And it wasn't just about picking the right form either. The rules surrounding these writs, they became incredibly specific, incredibly complex. And if your claim, for whatever reason, didn't fit neatly into an existing writ, well, you were basically out of luck.
No writ, no remedy. That must have been frustrating.
Incredible.
You're trying to navigate this system, you hit a roadblock, and it's like, what do? Give up.
Right. It definitely created some challenges, to say the least. And we'll dive into just how those challenges played out after this. So we left off with the writ system, a system that, while innovative for its time, well, it definitely had its limitations.
To put it mildly.
To put it mildly, yes. Imagine being told your grievance, something you're deeply convinced is wrong, can't even be heard because of some legal technicality.
Oh, I can only imagine the frustration. Be like, sorry, your claim is valid, but you filled out the wrong form, so tough luck.
Pretty much. So you can see how this system, while trying to create order, ended up creating its own set of problems.
Absolutely. So what did people do? Did they just accept this writ-based fate?
Well, they had another option, one that took them straight to the top.
Ooh, going straight to the top. Interesting. Who are we talking about here?
The king himself. Remember, in those days, the king was seen as the ultimate source of justice.
The fountain of justice, or so they say.
Exactly. So if you felt like the common law system had failed you, you could always try petitioning the king for a fairer outcome.
Wow, bold move. Did the king actually listen to these, please? I mean, running a kingdom seems like a full-time gig, right?
It was, but these petitions were taken seriously. Initially, the king's council would have handled them, but as you can imagine, with a growing kingdom and all, the workload became a tad overwhelming.
A tad, right.
Yeah.
So they needed to create like a medieval legal help desk to handle the overflow.
That's a pretty good way to put it. And that's where the chancellor enters the picture, often a high-ranking official, often a clergyman, tasked with handling these special requests for justice.
So the chancellor becomes like this medieval legal superhero swooping in to save the day when the common law system lets people down.
In a way, yes. The chancellor became the keeper of the king's conscience, responsible for resolving disputes based on principles of fairness, of what was right, what was equitable.
And that's the birth of equity.
You got it. This whole new system running parallel to common law.
Okay, I'm starting to see why this duality in the English legal system was so important.
It really was a game changer.
But what exactly did equity look like in action? I mean, how did a case decided under equity differ from a case decided under common law?
Now that's where things get really interesting. Instead of relying solely on precedent, those past rulings and those strict procedures we talked about, equity took a step back. It asked, hold on, what's fair here? What's the right thing to do, considering everything?
So it's less about the letter of the law, more about the spirit of justice.
Exactly. And to guide this pursuit of fairness, equity developed its own set of principles, often summed up in these pithy sayings called maxims.
Maxims. Sounds very official.
They were. Think of them like guiding principles, like, he who comes to equity must come with clean hands.
Oh, I've heard that one. Basically, you can't seek help from a court of equity if you haven't acted in good faith yourself.
Right. You can't benefit from your own wrongdoing. Equity wasn't about rewarding those who were trying to game the system.
Yeah, it makes sense. You want justice, you got to approach it with clean hands.
Precisely. And that emphasis on fairness, on looking beyond the strict letter of the law, it's reflected in another key maxim of equity. Equity looks to intent rather than form.
So it's not just about what you did, but why you did it.
Absolutely. Equity cared about the substance of a matter, the underlying intentions, more than getting bogged down in technicalities.
That's so interesting because you can really see how these centuries-old ideas about fairness, about looking beyond the rigidity of rules, continue to influence our legal system today.
Absolutely. These weren't just abstract principles. They had real-world consequences for how cases were decided and what remedies were available. And speaking of remedies, that's another area where we see a stark contrast between common law and equity.
Okay, because it's one thing to talk about fairness and equity, but how did those ideals translate into actual, solutions in the courtroom?
Right, because at the end of the day, you need a resolution, a way to make things right. And that's where the remedies offered by each system really differed.
So if common law was all about financial compensation, what could you get from a court of equity?
That's a great question that gets right to the heart of the matter. While common law was largely limited to awarding damages, equity had a much more diverse toolbox of remedies at its disposal.
Oh, so less pay up and more, let's find a solution that actually addresses the issue.
Exactly. Instead of just saying, okay, someone pays someone else money, equity could issue orders to prevent harm, enforce promises, even undo agreements. It was about finding a solution that fit the situation, not just applying a one-size-fits-all approach. So picture this. Someone is chopping down your trees you specifically told them do not touch. Common law, it would look at that situation and say, okay, well, those trees had value, so we'll figure out how much they were worth, and the person who chopped them down, they can pay you back. But equity took a different approach.
Let me guess. A bit more proactive.
You could say that. Equity could issue what's called an injunction, basically a court order that says, stop cutting down those trees right now. It wasn't just about dealing with the aftermath, it was about preventing further harm from happening in the first place.
So it's like hitting the brakes on a wrong that's still in progress, not just assessing the damage after the fact. Were there other remedies that worked like this?
Oh, absolutely. Let's say you had a contract with someone, and they swore up and down that they were going to sell you this one-of-a-kind artifact, something you've always dreamed of owning. Now, if they break that promise, common law, it might just say, all right, well, we'll give you some money to make up for it. But equity could step in and say, nope, a deal's a deal, and order the seller to actually hand over the artifact, just like they originally promised.
So in situations where, like, money couldn't really fix the problem, equity could step in and say, no, we're going to find a solution that actually sets things right. It sounds like a powerful tool. But I imagine having these two separate systems, each with its own, like, quirks and rules, that must have created some tension, right? Some confusion.
Oh, absolutely. Especially by the 19th century, it was becoming clear that something had to give.
Yeah, I can only imagine the headaches.
Imagine trying to navigate this legal landscape where it's not always clear which court has the authority to hear your case, which set of rules applies. It was a mess.
So enter the legal reformers. What did they do? Did they just scrap one system entirely or try to, like, blend them together?
They went for a bold move, a merger. The Judicature Acts of 1873, 1875, they came along and said, no more separate courts for common law and equity. We're creating one system.
One system to rule them all. Did it work? Was it a smooth transition?
Well, I wouldn't call it a complete overhaul. It was more like, okay, instead of having these two separate streams flowing side by side, they now flowed together within a single system.
Okay, so judges could now wear both their common law and equity hats, choosing the approach that made the most sense for the situation.
Exactly. It brought much-needed flexibility and paved the way for a more nuanced application of the law. And importantly, this wasn't just some abstract legal theory. It had real-world impacts on how disputes were resolved and how justice was carried out.
It's amazing to see how this journey from those early writs in medieval England to the merger of common law and equity, how much the legal system has adapted and changed over the centuries.
It really is remarkable.
And it just goes to show that these principles, these ideas about fairness and justice that we often take for granted, they weren't just handed down. They were fought for, debated, and refined over generations.
It's a legacy that continues to shape our world today, and it makes you wonder, how will common law continue to adapt in our rapidly changing world? What new challenges will it face, and how will it evolve to meet them? Those are questions worth pondering.
They certainly are. And on that note, we'll leave you to ponder them. This has been a fascinating deep dive into the world of common law, from those early medieval writs to the courts we see today. It's a system shaped by history, by power struggles, and by this constant striving for justice, a system that, even centuries later, continues to impact our lives in countless ways.